Okay, we are live. Hola, buenas tardes. Mi nombre es Génesis Castro. Yo manejo los programas del Fondo Comunitario Latino. Nos da mucho gusto estar aquí con la abogada Esther Bradford a hablarles sobre la tercera parte de nuestra serie de derechos de vivienda. Hoy vamos a hablar sobre las contrademandas y cuáles son las razones por las que uno puede contrademandar su arrendador si lo están tratando de desalojar. Go ahead, Esther, introduce yourself.
Hi, everybody. So today we're going to be talking about counterclaims. This is the third in a three-part series. If you haven't watched the parts 1 and 2 of the series, I encourage you to do so that you'll understand the basic steps of an eviction process and common defenses to an eviction. Today, specifically, we're talking about the counterclaims that you might be able to bring against your landlord in an eviction case. Now, counterclaims are how you tell the court that your landlord owes you money for things that may have happened during the time that you were a tenant or that they've done wrong during the tenancy. You might be asking the court to award you money, or you might be asking the court to dismiss the eviction and order the landlord to repair the property within a certain amount of time. I'll let Genesis translate.
Yeah, gracias. Como dijo la abogada Esther, hoy vamos a hablar sobre las contrademandas que puede presentar contra su arrendador en un caso de desalojo. Las contrademandas son una manera de como que usted puede decirle al tribunal que su arrendador le debe dinero por cosas que hicieron mal durante su arrendamiento. Tal vez le pida al tribunal que le otorgue dinero o al tribunal que desestime el desalojo para que el propietario repare la propiedad dentro de un cierto periodo de tiempo. Si no has visto la parte 1 y 2 de esta serie, te sugerimos que lo hagas para comprender los pasos de un desalojo legal y las defensas más comunes que se pueden levantar. Este programa es solo para fines de información general. Si se enfrenta a un desalojo y tiene preguntas legales específicas para su caso, debe hablar con un abogado. Su contrato de arrendamiento individual y los hechos de su caso harán una gran diferencia en si sus contrademandas son válidas y exitosas.
As Genesis said, this program is just for informational purposes. If you are facing an eviction and you have legal questions specific to your case, then you should speak with an attorney, because your individual lease and the facts of your case are going to make a big difference in the validity and strength of your counterclaims and your defenses. So first of all, defenses and counterclaims are different. Defenses, which we discussed in part 2 of the series, are the reasons why the landlord doesn't have the right to evict you, either because they don't have a valid reason to evict you or because they didn't follow the correct legal process. Counterclaims are the reasons why you have a case for damages against your landlord. You might be evicted and also have valid counterclaims that reduce the amount of back rent or fees that you judge to owe to your landlord. So it's important to understand your counterclaims and to write them on your answer and tell the judge about them in court. In other words, you might not have any valid defenses to your eviction. There may not be a good reason why you should be allowed to stay in your apartment, but your landlord may have done things wrong during the time of your tenancy that might reduce the amount of money that you owe, or that might even mean that the landlord owes you money.
Ya, eso es muy importante. Es importante entender que las defensas y las contrademandas son diferentes. Las defensas que discutimos en la parte 2 son las razones por las cuales el arrendador no tiene derecho a desalojarlo, ya sea porque no tiene razón válida para desalojarlo o porque no siguieron el proceso legal correcto. Las contrademandas son las razones por las cuales tiene un caso por daños y perjuicios contra su arrendador. Usted puede ser desalojado y también tener contrademandas válidas que reducen la cantidad de la renta atrasada o los honorarios que se le debe al arrendador, por lo que es importante comprender sus contrademandas y escribirlas en su respuesta a informar al juez sobre ellas en el tribunal.
So you're almost always in a stronger position to bring counterclaims if you're current on your rent. Obviously, sometimes that's just not possible. We know that. But many people are mistaken and they think that they can stop paying rent if their landlord isn't repairing something in the property. But that's not true. In Georgia, if you are living in a property, you have to pay rent. Withholding rent to try to get your landlord to repair a problem is a mistake that can remove a lot of your legal protections.
Yeah, es muy importante. Casi siempre está en una posición más fuerte para reclamar a su arrendador si está al tanto y al día con su alquiler. A veces simplemente no es posible, pero muchas personas se equivocan al decir que pueden dejar de pagar el alquiler si el propietario no reparó algo. Eso no es verdad. Es importante que si quieren que su arrendador arreglen algo, que siguen pagando la renta si pueden. En Georgia, si vives en una propiedad, tienes que pagar el alquiler. Retener la renta para intentar que el propietario repare un problema es un error que puede eliminar muchas de sus protecciones legales.
So the first counterclaim is kind of a mix of a counterclaim and a defense, and that is the protection that tenants have under the Georgia retaliatory eviction law. Georgia law says that your landlord can't evict you or reduce services to you within 3 months of you complaining about a serious habitability problem in the property. So these are the big repairs. If major appliances don't work, if the HVAC system doesn't work, if there's no hot water, if the structure is falling apart in dangerous ways. This law also protects people who organize tenant unions and associations to try to address habitability concerns. So it might not be your apartment where the floor is caving in, but maybe you have organized your neighbors into a tenants group and encouraged them to call code enforcement together. If you have led a tenant union, or if you've asked for repairs of serious problems in the property, and then your landlord evicts you within 3 months, or they terminate your lease within 3 months, or they stop doing basic services for you that they do for all the other tenants, things like picking up your garbage or forwarding your utility money to the utility company, that sort of thing, then you can ask the judge to dismiss your eviction case, and this is the counterclaim part. You can ask the judge to award award 1 month's rent plus $500 plus all of your attorney's fees and costs, and your landlord will have to pay that to you. Now, it's important. This law only protects people who are current on their rent, and it only protects people who have not been up to serious misconduct on the property, like criminal activity or creating safety hazards that could really harm someone on the property. But it's an important protection for people who are speaking up about repair issues in the property. If you speak up and then your landlord tries to evict you or terminate your lease within 3 months of that, you might have a retaliatory eviction claim, and you should speak to an attorney because your attorney's fee will be paid by the other side potentially under the statute.
Lo que ya acabo de decir es muy importante. Una de las contrademandas es el desalojo por represalia. La ley de Georgia dice que su arrendador no puede desalojarlo ni reducirle los servicios dentro de los 3 meses posteriores a su queja por problemas graves de habitabilidad en la propiedad. También protege a las personas que organizan sindicatos o grupos o asociaciones de inquilinos para abordar los problemas de habitabilidad. Si ha dirigido un sindicato de inquilinos o ha solicitado reparaciones de problemas graves en la propiedad y luego el propietario lo desaloja o rescinde su contrato de arrendamiento dentro de los 3 meses de haber realizado esa acción, puede pedirle al juez que desestime su caso de desalojo y ordene a su arrendador para pagarle un desalquiler más $500 y los honorarios de su abogado y los costos judiciales. Esta ley solo protege a las personas que están al día con el alquiler, o sea, que están al tanto con la renta, que todavía están pagando la renta, y que no se han involucrado en una mala conducta grave y que no han cometido ningún crimen en las instalaciones o creando condiciones peligrosas en la propiedad. Es importante reconocer que si como un inquilino usted tiene derecho de pedirle quejas al arrendador, ellos no pueden desalojarlo solo porque están diciendo quejas o están pidiendo que reparen la propiedad. Yeah.
So another common counterclaim is that you've been living in this property paying rent for however long, and the landlord has not been repairing the property. Georgia law says that a landlord has to keep the property in livable repair. So, cosmetic things like smudges on the paint or scratches on the floor are not what we're talking about here. We're talking about serious repair problems that make it so that it's not a safe, habitable, peaceful place to live. So, if the landlord doesn't keep the property in repair, you can ask the judge for all of the money that you lost because the landlord failed to repair the property. And that can take a lot of forms. Some of the common types of damages you can ask for because of your landlord's failure to repair are things like reimbursement for time or money or labor that you spent yourself to repair the property. If you have construction skills and you normally get paid X amount of money per hour to work with those skills, and you had to spend 10 hours repairing something in the property, that's worth money and you should ask for that. Or if you spent your own money to repair parts of the property and you have the receipts and you can prove that, then you should ask for that back. Also, there's something called, the technical legal term for it is diminution of value of rent. But all it really means is that you want to be paid back for the difference between the rent you paid and the fair market value of the property in its broken condition. For example, if you were paying market rent, but the property didn't have a working kitchen, you were overpaying in rent, and you should ask the judge to award you a reimbursement of some of your rent. Now, this gets tricky because there's no rule about the amount exactly that you should ask for, but you should definitely come up with a percentage of the rent that you think is fair. Sometimes it's easy. Sometimes there are square feet or portions of the property that you can't use because they're flooded or full of mold or caved in or whatever. So you can just take that square footage and say, well, I couldn't use 1/3 of the property, so I want 1/3 of the rent back. There are other things where, nobody would rent an apartment at market value that didn't have a working kitchen. So if for a lot of the time you lived in a place, it didn't have a working kitchen or it didn't have a functional bathroom, then you can ask for a lot of that rent back. And the argument is nobody in their right mind would have rented this place knowing this. This is not a livable apartment. It shouldn't have been rented at all. Now, Genesis, don't be mad. I'm going off script a little bit here for translation, but you're never going to be able to take that value down to zero, okay? Because a roof and apartment is better than being on the street. It's better. It's worth more than not having anywhere to live at all. So don't go ask the judge for all of your rent back. Come up with a percentage that you think is reasonable and give your argument to why the apartment was worth less because of the repair problems.
Yeah. Entonces, la segunda contrademanda es si el propietario no reparó la propiedad, es su deber mantener la propiedad en reparación habitable. Si no lo hacen, puede pedir todo el dinero que perdió porque el propietario no reparó la propiedad. El propietario debe haber tenido aviso sobre el problema y no haberlo reparado en un tiempo razonable. Y eso, cuando dijimos esto, tampoco estamos hablando de reparaciones como cosméticas, sino, por ejemplo, si la cocina, no puedo usar la cocina, si no puedo usar el baño, si hay molde en el piso, si hay molde en la pared, y el propietario no arregla esto, usted tiene el derecho de decirle eso al juez. En un caso de contrademandas, usted puede pedir reembolso por dinero o tiempo de trabajo que usted dedicó a reparar la propiedad que el propietario no reparó. También puede pedir una devolución de la diferencia entre lo que pagaste en renta y el valor actual de la propiedad en su estado roto. Por ejemplo, si estaba pagando el alquiler del mercado, o sea, lo que dijo en el contrato, pero la cocina no sirve o, tú sabes, no podía usar el baño, estaba pagando en exceso del alquiler, porque si la casa tiene partes que no trabajan bien, el valor baja, ¿verdad? Ustedes estaban pagando en exceso el alquiler y debe pedirle al juez que le otorgue un reembolso de parte de su alquiler. No hay una regla sobre cuánto puede pedir. Mucha gente usa un porcentaje del alquiler o dicen que si el baño no se puede usar, el baño toma por 25% del apartamento. Ellos usan eso para no saber, pero no hay una regla. También lo que estaba diciendo Esther es que nunca pueden pedir todo el dinero, porque vivir en un apartamento con muchos problemas es mejor que vivir en la calle. Entonces nunca van a poder pedir un reembolso total. Yeah.
So another counterclaim that you might have because your landlord failed to repair the property is the value of any of your property that was lost or damaged because the landlord wasn't fixing the property. And this often takes two forms. So for example, if you told your landlord that there was a water leak and then months later, and they didn't fix it, and then months later the pipe bursts and the leak suddenly becomes a flood and you lose lots of belongings, your landlord should have to pay you back for that. That's their fault. It's repair problems that they knew about and didn't fix. You should list out all of your lost property and its value, and you should give that to the judge. Sometimes very serious injuries will happen because a landlord didn't repair property. If you or someone in your family has had a serious physical injury, or if you've lost all of your property because of something your landlord failed to repair, then you need to speak to a lawyer. You probably have a case that needs to be handled by an attorney in a higher court where you can get reimbursed for everything you lost. Magistrate court, where most housing cases are heard, can only reimburse you up to $15,000. So if you or one of your children has been seriously injured, sometimes that looks like part of a structure caving in and physically injuring someone. Sometimes that looks like the landlord failing to repair the locks on the exterior doors and someone breaking in and assaulting or shooting or harming someone in your family. If that's the kind of injury that you're facing, then you need to get an attorney to handle your case, because you've got you have bigger losses and bigger harm has been done to you than a magistrate court can handle. And the stakes are high enough that you probably shouldn't represent yourself in that case. You need an attorney.
So I heard my audio is good. I'm going to try without the Déjame saber si dice los audífonos se oye mejor. El que valor de la contrademanda puede cualquiera de sus propiedades que se perdió debido a que no reparó la propiedad. Por ejemplo, si un ordenador que había una de agua, luego meses después su propiedad fue destruida porque la fuga de repente se convirtió en una inversión, debe enumerar todas las propiedades destruidas y su valor entregar a esta lista del juez. Si ustedes pierden todo por vivir en el apartamento, y es la culpa del propietario, tiene el derecho de pedir remuneraciones por todo lo que han perdido. A veces pueden ocurrir lesiones muy graves debido a que el propietario no repara la propiedad. Si usted o alguien de su familia ha sufrido una lesión física grave o ha perdido toda su propiedad debido a algo que el propietario no reparó, debe hablar con un abogado. Probablemente tenga un caso que necesita ser manejado por un abogado en un tribunal superior, donde puede recibir un reembolso por todo lo que perdió. La Corte de Magistrados, donde se escuchan la mayoría de los casos de desalojo, solo puede otorgarle un máximo de $15,000. Pero si lo que han perdido vale más de eso, deberían hablar con un abogado para ver si pueden ir a otra corte.
And just a note on those failure to repair counterclaims. Anytime that you're going to say that your landlord owes you money because they did not repair the property, it has to be something that they knew about. So tell your landlord when things are broken in your property, and keep a record. Do it in writing. Text them, email them, send it in writing through a portal and print out a copy. Because the landlord is only liable for problems that they had notice of, that they knew about, and then failed to repair within a reasonable time. So you have to be able to prove that your landlord knew.
All right, I'm going to log into my phone to see if the audio is better. So give me 1 second.
We'll just wait for Genesis to get back. Thanks for watching, everybody, and I really hope this is a helpful program for everyone.
Sorry about that. I'm just going to grab these sounds clear, and then we'll...
Sure. All right, so.
All right, so lo que estaba diciendo Esther es que es importante que si tienen algún daño que le quieren pedir al propietario, ustedes tienen el deber de dejarle saber al propietario para que sea su responsabilidad y para que puedan pedir dinero después.
So sometimes the condition of the property is so bad that it's not safe to stay there, and you have to move out. And you've basically been forced to leave. So even though the landlord didn't evict you, in reality, you've been forced to move out and you have been evicted. The court considers that as if you had been evicted by the landlord's failure to repair the property. We call that a constructive eviction. You haven't actually been evicted in a court case, but we construe it as an eviction because the property was so bad that you couldn't stay. This is things like raw sewage leaks that the landlord knew about and didn't repair, or mold that is so bad that you just really, it's not safe for you and your family to stay in the home. Now, don't go say you've been constructively evicted because there was some mildew around the shower, right? I can't help you with that. Get you some spray bleach and but if you know, I've spoken with folks whose the whole house was so full of mold that it was growing on their clothing and their furniture, or if there are hazardous things like raw sewage leaking into your home, you cannot stay there. That is not safe. Or if code enforcement comes out and tells you in writing that your house is not livable, that they're going to force you to move out because it's not safe. That's a constructive eviction. Or if you have, you know, for example, a roof leak so bad that you can't live in the house or sleep in the house or keep your belongings in the house, or if parts of the house are caving in and you're scared that any minute the ceiling over the main living space could go and hurt you. That's constructive eviction territory. So if you have been forced to leave the property because the repair problems were so bad, then you need to ask the judge to dismiss your landlord's eviction case and award you damages for any costs that you have paid or any loss that you have had because your landlord didn't repair the property. This is like, this is that failure to repair counterclaim we were just talking about, except maximum level, right? This is they failed to repair the house to the point that it wasn't a livable house anymore. And so the damages that you might be asking for in a situation like this might be your moving expenses if you had to move suddenly and unexpectedly. It might be hotel expenses if you had to move your whole family into an extended stay hotel because your house suddenly wasn't livable. Lost profits if the landlord knew that the drains were a mess and they didn't fix it, and now everything you own is covered in raw sewage, you can't take that with you. It's trash. It's gone, right? So that's the sort of stuff that you need to be asking the court for if you've been constructively evicted. Now, constructive eviction means eviction. Don't still be living in the house talking about you've been constructively evicted. If it's really bad enough to claim that you've been constructively evicted, that means you cannot live there. You have to move out. Take everything you're going to take with you. Hand your landlord the keys. You can't stay living in a place and claim that you've been constructively evicted. Those two things aren't compatible.
Yeah. Entonces, lo que Esther acaba de decir es muy importante. Y también déjame saber si todavía se oye mal en los comentarios, porque yo lo puedo ver. La tercera contrademanda que puede presentar es el desalojo constructivo. Tienen que tener en cuenta que dice desalojo, entonces no pueden seguir viviendo en el apartamento o en el lugar si están usando esta contrademanda. El desalojo constructivo quiere decir que la condición de la propiedad es tan mala que ya se han tenido que obligar a irse, a mudarse. Aunque el propietario aún no lo desalojó, en realidad se vio obligado a irse. Esto puede ser porque hay moldo, porque se dañaron las tuberías y el agua se fue por todos lados. Puede ser porque, no sé, se cayó un árbol y ya es un peligro quedarse en la casa. Pero si vives en condiciones pésimas, o sea, muy malas, donde ya no se puede vivir, puede pedir, y se han obligado a irse, puede pedirle al tribunal que le otorgue daños por propiedad perdida, ingresos perdidos, gastos de hotel, gastos de mudanza o cualquier otro costo que haya pagado por tener que irse para escapar de los problemas de reparación. También puede pedirle al juez que desestime el desalojo porque el mal comportamiento de su arrendador ya lo ha obligado a irse. También quiero recordarles que para usar el desalojo constructivo como una contrademanda, ya no pueden estar viviendo en el lugar y tiene que ser condiciones donde ya no se puede vivir, tú sabes, porque era un peligro. Yeah.
Your landlord is not supposed to try to force you out without going through the legal eviction process. And if they're doing things to try to force you to leave the property without going through the eviction process in court, then you need to tell the judge that your landlord has been trying to evict you illegally themselves. And that can look sometimes like changing the locks. It can look like cutting off the utilities even though you paid your bill. It can look like refusing to accept your rent when you try to pay on time and in full. Now look, no landlord has the obligation to accept late or partial rent, okay? So what I'm talking about is the landlord who you show up on time to pay your full rent and they refuse to take it because they're trying to force you out, okay? It can look like intimidating or harassing you to try to scare you into leaving. Sometimes landlords will show up armed with firearms, or they will tell you really scary things about how they're going to call defects or call ICE, just to try to force you to leave, not because they actually think that they have a legal reason to call those agencies, just as a bullying tactic. So if your landlord has been trying to keep you out of the property by force or harass you and scare you into leaving, then you need to tell the judge that your landlord has been trying to do a legal self-help eviction and that you want their eviction case to be dismissed and you want damages for that.
Yeah. Entonces, otra cosa que es un poco común es el desalojo ilegal de autoayuda. Si su arrendador ya ha tratado de obligarlo a abandonar la propiedad y han hecho cosas horribles, ¿verdad? Como cambiar las cerraduras, cortar los servicios públicos a pesar de que pagó la renta, negarse a aceptar la renta cuando intenta pagar a tiempo y en su totalidad, si lo ha intimidado o acosado para tratar de asustarlo para que se vaya. Esto puede ser cosas como decir que van a llamar a inmigración, decir que van a llamar defects, decir que le van a quitar los niños, presentarse con armas. Si han hecho cosas como esas, puede decirle al tribunal que su arrendador ha estado tratando de hacer un desalojo ilegal en lugar de pasar por el proceso legal. Sí.
So another thing that you might have a counterclaim against your landlord for is if they have broken your right to have full possession of your property and enjoy it in peace. When you rent a home, you have the right to be the only person who has possession of that space. It's your home. Your lease will probably give your landlord the right to come in and inspect and make repairs, usually with notice to you unless there's an emergency. But if your landlord is constantly invading your space, if they're constantly coming in without notice, if they are blocking off your ability to use parts of the property that you rented, or if they are giving parts of your private space to other tenants, then you need to tell the judge and ask to be paid back for the fact that the landlord broke the lease. And importantly, this is considered to be a part of every single lease in the state of Georgia, whether it's written in there or not. So you may not see a part in your lease that says you have a right to quietly and peacefully enjoy your home without me coming in and messing that up, but it's in there. The law considers that it's in there just by the fact that you rented a home. Your home should be a space that you have the right to be in peacefully.
Yeah. Entonces, lo que vamos a discutir ahora es algo que se encuentra en todos los contratos en Georgia, aunque no esté escrito, ¿verdad? Todos tienen el derecho a tener la posesión total de la propiedad y disfrutarlo en paz. Entonces, cuando tienen una casa, ustedes tienen el derecho de ser las únicas personas que tengan posesión de ese espacio. Su contrato de arrendamiento le dará a su arrendador el derecho de entrar y hacer reparaciones e inspecciones, pero si su arrendador está constantemente invadiendo su espacio, entrando sin avisarle, invadiendo su privacidad o dando partes de su espacio privado a otros inquilinos, debe informarle al juez y pedirle que le pague por el arrendador que rompió el contrato de arrendamiento. Y aunque ellos pueden decir, oh, eso no está en el contrato, pero no, esa cláusula de sus derechos están en todos los contratos de arrendamiento en Georgia. Yeah.
Now, what about if your landlord just straight up lied to you? So now this is more rare than the other counterclaims that we've talked about. But you might have a counterclaim against your landlord for fraud and for lying. So for example, if your landlord told you that they were leasing you a nice, habitable, livable house or apartment, and they lied about a problem in the property that you would have had no way of seeing in a normal walkthrough before you signed your lease, then you may be able to prove that they committed fraud and that they lied to you to get you to sign your lease. For example, if you experience sewage leaks in your apartment that you couldn't have seen in a walkthrough, you don't go open up the walls and inspect the sewage pipes when you look at an apartment to rent, right? Nobody does that. That's unreasonable. But if you are having sewage leaks in your apartment that you couldn't have known about when you leased it, and it's terrible and it's destroying all your stuff and it's unhealthy, and then your neighbors or code enforcement tell you, yeah, gosh, that sewage has been leaking for months. That's why the last people left. Or we've cited these guys 5 times in the last year for this sewage leak, and they just keep painting over the walls and re-renting this apartment. Then you might be able to counterclaim that your landlord owes you damages because of their deception. And you might have a claim under the Georgia Fair Business Practices Act. So if you think that your landlord lied to you to get you to rent the property, this is one of those counterclaims that you should probably talk to an attorney. And the reason is that the Georgia Fair Business Practices Act forbids the sale or rental of real estate with deceptive or unfair means, right? So if you're painting over the sewage leak and not telling anybody and putting another tenant in there, and you knew that this was likely to explode all over their house with raw sewage, then you have been unfair and deceptive in the way that you leased that property. And the Georgia Fair Business Practices Act forbids that. And the Georgia Fair Business Practices Act and some of the other fraud and deception laws in the state of Georgia give you a right to triple damages and what we call punitive damages. So that's damages not to pay you back for what you've lost, but damages, additional damages on top of that to punish the landlord and make sure they don't do that again, right? And attorney's fees. So if you have suffered, a real deception that you couldn't have known about, that your landlord really lied to you, then you should talk to an attorney to see if you have a case where the landlord is going to have to pay your attorney's fees and you can get a lawyer to represent you. This does not cover things that you could have seen with your own eyeballs when you walked in. You cannot sue someone for fraud for having holes in the wall when the holes in the wall were there when you walked through the apartment. You said, yeah, okay, well, I can live with that, right? It's got to be stuff that they covered up. It's got to be deception. You can't sue somebody for stuff that you could have known by looking in the public record with a little bit of effort. So if you can't sue somebody because you thought it was this school district and it turns out it's that school district, right? Talking about things that your landlord knew that you couldn't have known and that your landlord lied about and it hurt you.
Yeah. Entonces, este último ejemplo de contrademanda no es tan común, pero todavía pasa. Y esto es si su arrendador, su propietario le miente o comete fraude. Si su arrendador le mintió sobre un problema en la propiedad que no habría podido ver cuando hizo un recorrido antes de firmar su contrato de rendimiento, puede probar que cometió fraude y mintió para que firmara tu contrato de rendimiento. Esto no es, por ejemplo, si uno entra en un apartamento y ve hoyos en la pared, eso no cuenta porque eso se ve. Pero si uno entra en un apartamento y todo se ve bien y resulta que la tubería no sirve y sus vecinos se dicen, oh sí, eso siempre pasa, por eso fue que los últimos que se fueron, eso cuenta, porque su arrendador no fue honesto con ustedes y le mintió. Sí, y también es importante que si Code Enforcement le dice que el propietario ha sabido y ya sabía que había un problema durante años y simplemente lo cubrió para obtener que usted le alquilara el apartamento, eso es fraude. Es posible que puede reclamar que su vendedor le debe daños por ese engaño y que también violó la ley de prácticas comerciales justas de Georgia. Si crees que su arrendador le mintió para que quedara la propiedad, debe consultar a un abogado. La ley de prácticas comerciales justas de Georgia puede otorgarle el derecho de rectificar los daños y hacer que el arrendador le pague a su abogado. Entonces, quiero mencionar eso de nuevo, que su arrendador cometió fraude, le mintió sobre algo y rompió la ley de prácticas comerciales justas de Georgia. Usted puede decirle al tribunal que le paguen los gastos y que le paguen lo que le cuesta tener un abogado. Entonces, es importante que sepan eso. Yeah.
So, those are some of the common counterclaims. Obviously, every situation is different. Trust your instincts. If you think there may be something strange or specific about your situation, then you want to talk to an attorney. If you have counterclaims, if you recognize some of the things that we've talked about in your case, then it is really, really important that you file your answer on time and that you appear in court on time for your hearing. Because if you do not answer, if you do not show up, or even if you're, an hour late, then you could automatically lose your case. So it's really important to file your answer and be early to court on your court date, because judges are not obligated to wait for you. And unfortunately, sometimes we have really good reasons why we were late. The car broke down, the baby got sick. We missed our bus. Things happen. So be early, because if you're not there when the judge calls your name, they might automatically lose your case. Counterclaims in eviction cases are what we call compulsory counterclaims, meaning that if you don't bring them up in your eviction case, when you file your answer and in front of the judge in court, then you lose the right to ever sue your landlord for those things again, potentially. You might lose the right to ever get paid back for the things that your landlord has done wrong if you don't bring them up in your eviction case. So it's very important.
Yeah, cuando lo que voy a decir ahora es muy importante. Si tiene contrademandas, es muy importante que presenten una respuesta a tiempo y que comparezca a tiempo en el tribunal para su audiencia. O sea, que no pueden llegar tarde, tienen que llegar a tiempo. Y algunas veces la gente tiene razones legítimas por las que llega tarde, pero no importa, tiene que llegar a tiempo al tribunal. Si no lo hace, perderá el caso automáticamente. También tienen que entender que las contrademandas en los casos de desalojo son obligatorios. Y eso quiere decir que si no es presente de una vez y como una respuesta a su caso de desalojo, puede perder el derecho de contrademandar su propietario.
People often ask me a lot in eviction case consultations about their security deposit. And that's really important, but it's separate from the eviction case. So your security deposit, you have a legal right to a refund of your security deposit or to a specific list of the reasons why you're not getting it back within 30 days of moving out of the property. So an attorney is not going to be able to help you with a security deposit problem until 30 days have gone by after you're moving out.
I'm going to skip this one. I'm preguntando, ¿ustedes son de su depósito 30 días de mudarse, por lo que o no es pago depósito de su.
I think your headphones may have been better audio from my end.
Okay.
This is clear when it's clear, but it's going in and out. My end.
Yeah.
So let's talk just a little bit about what to do on the day of your court date and how to prove your counterclaims. Okay, so first of all, bring evidence. Bring evidence of every fact that you're claiming is true. You want to bring 3 copies with you to court, one for you, one for the judge, and one to hand to the landlord or the landlord's attorney. You're going to bring any witnesses that personally observed the facts that you're claiming are true that you need to prove. Remember, you can get documents like code enforcement citations and police reports by sending open records requests to the correct agency. Those are government records, and if you fill out the open records request form, they have to give them to you. They might charge you a fee per page, but it's usually not crazy expensive, and you can ask them what the cost will be before, when you place your order. So, for example, if you know for a fact that code enforcement came out and issued a citation, but you don't have a copy of it anymore, get it from code enforcement before you go to court. Sometimes they'll give it to you, and sometimes they'll tell you to fill out an open records request. Don't be afraid to do that. That's your right as a citizen. Or as a resident, you don't have to be a citizen to do that. That's your right as a resident of the state of Georgia. And remember that you can force your landlord to bring certain documents to court by sending them what we call a notice to produce or a subpoena for documents. And the clerk of the court in the county where your case is can give you the right form and tell you how to send it. So, for example, sometimes people don't have a copy of their lease and their landlord won't give them a copy of their lease because it gives them an advantage in court. The landlord knows they're wrong, but they also know that you don't have a copy of it, right? Surprise them, send them a notice to produce or a subpoena and say, I want a copy of my lease, bring it with you to court. And that form will have the right wording. And you mail that to them, certified mail, And whammo, that is a legal requirement. They are now being basically ordered with the power of the court to bring those documents if they have them. So don't let yourself be bullied. You know, if your landlord, you know that your landlord has paperwork that would help your case, but they won't give it to you. Well, it's the cost of suing somebody. Suddenly they can subpoena documents. So you can, when you send those subpoenas and those notices to produce, send them certified mail and save a copy of the stamped certificate, because that is admissible in evidence. You can give that to the judge to prove that you served that subpoena or that notice to produce. And here's why that's important. And you probably want to file a copy with the clerk too in a magistrate court case, just so the judge knows that you did it. Here's why that's important. Because if the landlord shows up to court without the documents that you subpoenaed or that you told them to bring, you can say, Judge, I subpoenaed documents. I would like for you to continue the case and order them to comply with the subpoena. We're not ready to move forward today because they were supposed to bring a copy of these documents on my notice to produce, and they didn't. Judge, I'd like a continuance of the case, and I'd like you to order them to comply with the notice to produce or the subpoena. Don't let yourself be bullied. Don't let yourself be bullied. If you have questions about your particular case, then you need to consult with an attorney. These are all general information principles. I do consultations in half-hour and hour-long increments to help people prepare to represent themselves in landlord-tenant cases. So there are ways for you to potentially afford and access a lawyer's advice about your case, even if you can't afford a lawyer to represent you in the whole entire case. And that is all that I have about counterclaims. Those are the most common types, and I hope that that was helpful.
Yeah. So does this sound better?
Yeah, I can hear you.
Okay, good. Recuerda que si está contrademandando a su arrendador, tiene que traer evidencia de cada hecho que está afirmado que es verdad. Lleve 3 copias a la corte, una para usted, una para el juez y otra para el propietario o su abogado. Traiga testigos que hayan observado personalmente los hechos que necesita probar. Recuerde que puede obtener documentos como citas de cumplimiento de códigos e informes policiales, enviando solicitudes de registros abiertos a la agencia municipal correspondiente. Puede obligar a su arrendador a llevar ciertos documentos a la corte, enviándole un aviso para producir o una citación para documentos mucho antes de su audiencia de la corte. Si estás contrademandando a alguien, pueden obligarlo a que traigan documentos. Entonces, por ejemplo, lo que pasa muchas veces es que uno no tiene la copia de su contrato y el arrendador sabe que no tiene la copia del contrato. Pero si lo está contrademandando, pueden obligarlos que lo traigan a la corte. Y si ya van a la corte y el arrendador no lo traiga, tú le puedes decir al juez, mira juez, yo le pedí esto, no lo trajo, podemos seguir con mi caso hasta que lo traiga. Y ellos te pueden decir que sí. Y también puedes obtener un aviso para producir en la oficina del secretario de la corte. Es importante que lo envíe en correo certificado y que guarde una copia. Perdón, me perdí. Y el certificado de correo certificado para que tenga el día en que tú lo mandaste. Si el arrendador te presenta a la corte sin los documentos que necesitas, como dije, muéstrale al juez y puedes pedir una continuación hasta que el arrendador presente los documentos. Y también tiene que tener en cuenta que cada caso es particular, cada caso es diferente. Entonces es importante que hable con un abogado para hablar sobre su caso. Esther estaba explicando que ella hace consultaciones. Ella hace consultaciones de media hora o de una hora, dependiendo de las necesidades de sus clientes. Pero si usted cree que tiene el derecho de contrademandar a su arrendador, es importante que hablen con un abogado.
Oh, sorry. Go ahead.
No, go ahead.
So one last thing that's important that I didn't think about before, but I think people need to know is that, it's very, very common for eviction cases to be settled either in mediation or in the hallway of the court. You often work something out with your landlord. Make sure that you feel that your counterclaims are fairly addressed in any settlement that you work out with your landlord. If you settle the case, you settle the whole case. You're not going to get a chance to settle your landlord's eviction of you and then go talk to the judge about your counterclaims. So make sure that if you agree with your landlord and you guys are giving the judge a settlement to sign, that you feel good about how it compensates you for your legitimate counterclaims.
Yeah. So let me see if this helps. Pues lo que estaba explicando Esther es que es posible, y esto pasa en muchos casos, que los casos de desalojamiento, donde haya contrademandas, se resuelven fuera de la corte y con un mediador. Si este es el caso y están hablando con un mediador para resolver el caso, es importante que usted siente que sus contrademandas fueron cumplidos y que cualquier daño que usted cree que se merece, que se lo den. Y es importante que entiendan que eso es aparte del proceso de desalojamiento. Que una cosa es el proceso de desalojamiento, lo otro es que sus contrademandas son cumplidos. Great. So Esther, we do have a few questions this time.
Great, I'll be happy to answer those. If I can. I can't answer specific questions about your specific case, but I can give general legal information.
So someone asked, what laws does a landlord have when rent is not paid for 3 months? I guess what rights?
Well, the landlord has the right to follow the legal eviction process and to ask for payment of rent through the time that the tenant is actually evicted.
Entonces, go ahead.
But there is, the legal eviction process is very specific. So I would encourage a landlord who wants to do it ethically and properly and not waste their time to talk to an attorney.
Entonces la pregunta fue, I'm going to switch screens and see if it sounds better. Give me 1 second.
You sound clear to me.
Does it sound better? Does it feel like a really bad echo?
There's a little echo, but you sound pretty good. You sounded good before to me.
Okay.
Yeah. Good. So a landlord has the right, if somebody's not paying rent in your property, you need to talk to an attorney because every case is specific and it depends on your lease. It depends on the type of tenant that you have. And it depends on some other things that are just too complex and specific to get into because this is a webinar on tenant rights. Hello.
Yeah.
But of course, a landlord has rights. If the tenant's not paying rent, that's what the whole eviction process is for. You just need to do it properly and ethically and follow the right procedure for the specific type of tenant that you have.
So la pregunta que cuáles derechos el propietario si uno no paga la renta y si no la ha pagado en 3 meses. En ese caso, el propietario tiene el derecho de seguir el proceso legal de arrendamiento. Eso se sabe por la corte, darle tiempo al inquilino, pero sí tiene derechos. So I saw a very good question earlier. Let me see if this. So the question was, can tenants without documentation status go to the magistrate court to be compensated for damaged property?
Yeah, yeah, you can. Absolutely, you can. You have the right to be heard in court and to get due process for your claims. Now, I would be remiss if I didn't tell you that some landlords will use undocumented status to bully people, and they'll threaten to call immigration authorities on you, or that kind of thing. And that's a little outside of the scope of this presentation. It's important to know your rights, to know your rights as far as entry into your home and that kind of thing. Yeah, you absolutely have the right to, if you are a party to a contract, which is your lease, and you have been paying rent or living in a property, and someone has broken that contract with you and taken you to court, yeah, you have the right to present your counterclaims. You have due process rights. Yeah.
Sorry, I was muted.
And I will say, if you are representing yourself and you are in court and the landlord or the landlord's attorney wants to start asking you questions under oath about your immigration status just to bully you and scare you, object. That has nothing to do with whether you paid your rent or not. It has nothing to do with whether the pipes leaked in your apartment. It is irrelevant. And in Georgia evidence law, an attorney is only supposed to ask questions about things that are relevant to the reason that you're in court. So I would say, don't be shy about saying, Judge, I object. It's irrelevant. I don't want to answer questions about my immigration status because it has nothing to do with this case today, which is an eviction case about whether I paid my rent and whether my landlord fixed the property. That's what I would do if I was your attorney in court. So do it for yourself if you're there by yourself.
Entonces, la pregunta fue que si una persona no tiene documentos, si ellos todavía tienen el derecho de ir a la corte magistral para pedir reparaciones o pedir compensación por propiedades que necesitan reparaciones. Y la respuesta es que sí, aunque no tengan documentos, sí tienen derechos. Lo único es que tienen que tener en cuenta que pueda que el propietario, le trate de asustar y mencionar eso en la corte, pero aunque uno no tiene documentos, todavía tiene el derecho de pedir compensación. Y si el propietario trata de decir eso en la corte y preguntarle sobre su estatus legal, ustedes, la abogada dijo que esto es lo que ella haría si ella fuera su abogado. Ella dirían que su estatus legal no tiene nada que ver con si pueden pagar la renta, porque en el caso de desalojo tiene que ver si el propietario tiene derecho de desalojarlo, pero su estatus legal no tiene nada que ver con si su arrendador tiene el derecho de desalojarlo. And then there was one more question from Dia, and it asked,
I will say, I just want to say about that last question real quick. If there is no reason that your landlord has the right to evict you and their attorney, and they have an attorney, and their attorney is trying to threaten you with calling ICE to make you leave, it is against that attorney's rules of professional ethics to do that, okay? They are not supposed to threaten you with prosecution in order to win a civil litigation case. That is against Rule 3.4 of the Rules of Professional Conduct, and you should file a bar complaint against them. That is not okay, in my opinion, for an attorney to threaten you with prosecution just for the purpose of winning a civil case against you in your eviction case. And you should tell the judge. Tell the judge, Judge, I heard this was a violation of Rule of Professional Conduct 3.4, and I want to complain about it. This is not okay. They're threatening me just to win this civil case, and that's not professional, Judge.
Algo más que quería decir es que si su arrendador trata de seguir con el proceso de desalojamiento, pero ellos no tienen un basis, o ellos no tienen un basis legal para desalojarlo. Y si el abogado del arrendador menciona su estatus legal y trata de decir eso, que eso es una razón, eso no es ético, eso va contra las reglas de profesionalismo de los abogados. Y usted le puede decir al juez que usted le puede mencionar eso al juez y hacer un complaint sobre eso. Yeah. And then one last question that we have is, what do I do if my landlord won't accept my rent payment?
So if you are trying to pay your rent, first of all, let me clarify again that your landlord does not have an obligation to accept late rent or partial rent. But if you are trying to pay your rent in the way that you usually pay it, in full, now, if your lease, we talked about this a little bit in part 2, but if your lease says that rent is due on the 1st, but for 3 years, every month you've paid it on the 10th, then that's different. Paying on the 10th is now paying on time, because that's what you and your landlord have agreed to by the fact that that's how you've been doing it for 3 years. But if you are trying to pay your rent in full and on time, and your landlord won't take it, you should save the evidence of your attempt to pay. You might even record your trip to the office to try to hand in the money with your phone. You might, if you try to pay through a portal with a credit card or a bank withdrawal and they refund it and send it back to you, save that receipt of that rejection. If you tried to pay with a money order, save a copy, bring the money order to court with the date and the purpose of the money order. Document the evidence of your attempt to pay on time and in full. Might even tell your landlord, hey, if you're going to refuse to take my rent, I want you to sign this receipt that I tried to pay you and you wouldn't take it. Some landlords don't realize that what they're doing is really stupid. they might actually sign it. I don't know. But just document your effort to pay. And the reason that you want to document your effort to pay is because in Georgia, the law says that if you owe somebody money and you try to pay it in full and on time and they refuse to take it, it's as if you paid. The law considers that the same as payment. It's not your fault if you showed up with your money and they wouldn't take it, right? Now, and so basically you can say, Judge, I tried to pay my rent, and you'll see, we talked about this a little in the defenses part. You'll see that there is a checkbox on the Fulton and DeKalb County answer forms to say, I tried to pay my rent, all of it, on time, and the landlord wouldn't take it. That is a defense to an eviction for non-payment of rent. Now, if you've been late for months and the landlord has already filed an eviction against you, not only do they not have to take your rent, but they'd be unwise to take it. Because then if they do take rent, if you're being evicted because you didn't pay rent, and then your landlord takes rent between the time they file the eviction case and the time you go to court, you can ask for that eviction to be dismissed. So you don't have, the landlord's not obligated to take rent from somebody who's behind on their rent and who's already being evicted. There's a little more to that. You have your right once per year to pay and stay, and we talk about that in depth in part 2, so I'm not going to repeat it all here.
No, la pregunta fue que qué debe hacer uno si el arrendador o el propietario no quiere aceptar su pago de renta. Y lo primero que queremos decir es que si es tarde o si no es toda la renta, ellos no están obligados a aceptarlo. Pero si es a tiempo, déjame decir algo, al menos que ellos, digamos que ustedes han estado viviendo ahí por 3 años y cada mes, esos 3 años, ustedes pagaron la renta 5 días tarde, pero ellos nunca dijeron nada. Entonces, tenés un caso como este, donde hay un récord de que ellos estaban aceptando la renta tarde y eso fue, y estaba por ciertos días y eso estaba bien con ellos, entonces no cuenta. Pero si no es así, si es como la primera vez que lo están pagando tarde y ellos no lo quieren aceptar, ellos no están obligados a aceptarlo. Pero si están pagando la renta a tiempo y es toda la renta y ellos no quieren aceptarlo, ellos no quieren aceptarlo, usted le puede decir a ellos que firmen un recibo diciendo que usted está tratando de pagarlo, pero ellos no lo están pagando, ellos no lo están aceptando. Porque en Georgia, si uno paga algo, tú sabes, a tiempo, en la cantidad total, y los otros no lo aceptan, es su culpa y es como si el que está pagando, lo que está queriendo pagar, ya lo pagó. Si un propietario ha empezado el proceso de desalojo legal y ellos aceptan su pago de alquiler, aunque no sea todo el dinero, pues si ellos aceptan una cantidad de dinero para el alquiler, luego usted puede ir al juez y decir, mira, ellos aceptaron este dinero, por favor, desestime mi caso. Pero sí, hay más información sobre eso en nuestra segunda parte, que se trata sobre las defensas legales al proceso de desalojamiento. Yeah. I think that's it for the questions. A menos que alguien más tenga una pregunta. Pero si no, I mean, thank you so much, Esther, for your time, for bearing with the technical difficulties and giving great information about people's counterclaims and what they can file as counterclaims for a legal eviction process. También muchas gracias a Esther por dar información tan importante sobre las contrademandas legales en el proceso de desalojamiento. If you guys would like a consultation with Esther, she is a housing attorney, and her email and phone number will be posted in the comments to this video. Si usted cree que necesita un abogado de vivienda, Esther hace consultas, y vamos a poner su número de teléfono y su correo electrónico en los comentarios. But we hope that this series has been helpful to you guys. Again, this is part 3 of a 3-part series. This one was on counterclaims, the second one was on legal defenses, and the first one went through the legal eviction process. Esperemos que esta serie haya sido útil para ustedes. Esta es la tercera parte de nuestra serie sobre derechos de inquilinos. Este video se trataba de contrademandas. El segundo video se trataba de defensas legales al desalojamiento. Y el primer video se trataba sobre el proceso legal del desalojamiento. But yeah, Esther, I don't know if there's anything else that you'd like to share before we close out, but thank you so much for your time.
Yeah, and I also do, I do help landlords who are trying to be ethical and trying to do evictions the right way, but that's kind of a different set of information. And so if people have questions about that, I'm happy to consult about that too. And I do a lot of preventative care to keep landlords from falling into unethical behavior that can cost them a lot of money and harm tenants. So I'm happy to talk about that. It's not in the middle of a webinar on tenants.
Entonces estaba diciendo que ella también ayuda a los arrendadores a, tú sabes, empezar el proceso de desalojamiento, un proceso ético y legal, pero esto no es la razón por este taller. Pero si uno quiere hablar con ella personalmente, ella puede hablar con ella y hacer una consulta.
Bye, everybody. Have a great night.
All right. Thank you, guys. Que tengan buenas noches. Bye.